Select Committee on State and Federal Power and Responsibility will now come to order. Before the clerk calls the roll, I just want to mention that you may see some of the members get up and move in and out. There's a couple of reasons for that. One of the most important one is they've got lunch in the back, and even though I know y'all are missing lunch, they really don't want to unless they have to. So we've got a microphone back there, so if you do see them step out, it's not due to lack of interest at all. It's because they're back there finishing their meal they already started. So we may see a little bit of that, but they'll hear the testimony. Also, we have some competing hearings going today, and some of these folks are on another committee that is meeting at this time. And so they're going to be kind of skipping out, in and out as well. So please don't take that from any of them as being a lack of interest, but it's just the demands of the schedule during the session. So with that, the clerk would please call the roll.
Chairman King.
Here.
Vice Chair Workman.
Here.
Representative Anderson.
Here.
Representative Parker.
Here.
Representative Miles. Representative Wally.
Here.
Representative Clardy.
Present.
Great. Quorum's present. This is the, I guess, first official hearing of the of this committee. It's first off, I want to welcome all the members, and just really excited that you're with us here today. Also, we have some visitors, Mark Keogh, representative, and then Phil Stevenson and Rick Miller have joined us up here at the dais. They're not on the committee, but gentlemen, feel free to ask any kind of questions and participate just like you were a member of this committee, because as far as we are concerned, you are anytime you're up here. The committee has a pretty broad charge that the House members have given it. We'll be dealing with a lot of the 10th Amendment type issues, and those will always be kind of fun and colorful, at least. We'll probably take those up specifically on some of the days to come, and have if I'm anticipating some Second Amendment bills, we'll probably maybe have a Second Amendment day and some other things, and maybe try to divide it up topically, depending on how the bills get referred. Specific in the charge is a direction for us to take up questions concerning Article 5 of the U.S. Constitution, which will be laid out today. We're only going to take invited testimony today, and I suspect that anybody is in the room probably already knows what Article 5 is about. We have live streaming today, I think, and so if we're watched online, simply that the Constitution provides for two ways in which the Constitution can be amended. One is through actions of Congress, and one is through actions of the states working in concert. And so today we have invited testimony on this topic, and this topic alone. I know a lot of you may be interested in testifying on some of the bills that will come up regarding Article 5. We're not going to lay out formally any of those bills today. We'll do that hopefully either next Thursday or the Thursday after that. And at that point in time, we'll open it up to testimony from the public, and the bill authors will be presenting their cases, and we'll have specific testimony that they brought in as well. So that's a great time and opportunity, and we invite you to testify before the committee at that time. Today will just be invited testimony, and we've tried to kind of cover the bases with it. There seems to be kind of three schools of thought on how to approach Article 5 if the states were to go in that direction. And then there's obviously some groups that are opposed to going in one direction or the other, or going in any direction at all. And so for today, we'll have testimony from, I think, all of those schools, as well as from some very qualified folks that have concerns about an Article 5 approach. And so the members will have opportunity to ask any questions of the witnesses as they testify. Members, I've asked the witnesses to try to hold their testimony to 15 minutes. If it fudges a little bit beyond that, that's okay. Please don't stray too far beyond that if you can. And then after each testimony, we'll open it up to the members as far as you want to go, and as long as you want to go on questions is certainly appropriate. Any of the members have any comments they'd like to make? Armando, go ahead.
Chairman, thank you. I appreciate the opportunity to be on the committee, being the only Democrat on the committee. But,
oh, you've got one more. You've got Miles.
Present.
Miles. Present. Yeah.
But just wanted to say that I don't shy away from a vigorous debate, but I do got to go to Article 2. My article is, we're still marking up the Health and Human Services, and I just wanted to welcome Senator Coburn from Oklahoma. We had a nice discussion in the back. Even though our opinions differ, he was very gracious and warm, and so I just wanted to welcome him to Texas and appreciate you. And whenever you're back in Houston, would love to catch a cup of coffee or something. Thank you, Senator, for being here.
And we're delighted you're on the committee and delighted your perspectives on the committee. Thank you. Anyone else? Great. Well, I'm trying to think if I've left anything off my committee clerk's list. I think we can get started. If everyone's ready, the chair calls Senator Tom Coburn from the Convention of States. The senator is a former United States Senator from Oklahoma. He served for 10 years in the Senate and was a congressman for 6 years prior to that. He's also a medical doctor by profession and has recently joined the Convention of States project as a senior advisor. Senator Coburn, would you join us at the podium, please?
Mr. Chairman, could I ask that Mike Ferris go before me, because he actually has a flight ahead of me out of
Absolutely
Texas,
can.
if I
All
might.
right, let's do that. Mike Ferris, you want to come up? Chair calls Mike Ferris from the Convention of States project. Mike is the chancellor of Patrick Henry College. He's the chairman and founder of the Homeschool Legal Defense Association and is currently serving as project director for the Convention of States. And Mr. Ferris and I had breakfast at ALEC's conference this summer, and he was there to give testimony before a working group there, and really glad to have you in Texas today. And just for the record, would you please state your name and tell us who you're representing?
Sure.
Oh, good. Let the record reflect that Representative Miles is present.
Thank you. Mr. Chairman, members of the committee, it's an honor to be here with you today in the Texas Legislature. My name is Michael Ferris. I am the Chancellor of Patrick Henry College, where I teach constitutional law and coach our moot court team. We are honored to be a part of a league of schools that debate in moot court, including a number of schools in Texas. I want to start my testimony by perhaps taking more of the role of a constitutional law professor and teaching you what I didn't learn correctly in law school or in undergraduate school or grade school, for that matter. I was taught the opposite history, and I'll try to do it very briefly. And most of us were taught that the Constitution was a result of an illegal runaway convention. And a lot of the concerns that people have about the Article 5 process are driven by that false history. And so, while people can, even if they get the history correct, can still have valid reasons in their own mind as to whether or not they want to support this idea or not, we should all get the history about the Constitution correct, and we should all have confidence that our Constitution was, in fact, legally adopted. And so the basic idea for the notion that it was illegally adopted comes from this. In February of 1787, the Congress, under the Articles of Confederation, people call it the Continental Congress. That's not accurate. It's the Confederation Congress. The Confederation Congress endorsed an application process that was ongoing at that time. The Articles of Confederation did not give that Congress any authority to call any conventions for any purpose whatsoever. And we all should know enough history about that period to know that the Articles of Confederation gave Congress no implied powers whatsoever. But what that Congress did was to pass an endorsement resolution. It had no more authority than a National Pickle Week resolution does today by Congress. And it simply was endorsing a project that the states were already undergoing. 7 states, prior to Congress acting, had already called for the Constitutional Convention, named their delegates by name. Virginia, for example, they named James Madison and George Washington and so on, and had given their instructions. And their instructions was this: to render the federal Constitution adequate for the exigencies of the Union. Now, it was Congress that added the phrase, only amend the Articles of Confederation. And the historical confusion has been to attribute to that Congress the authority to call the convention. Nobody contends that Congress had the authority. The way you can see that real clearly, the best historical document, is to go read the Annapolis Convention resolutions, because at the end of the Annapolis Convention, they said, we don't have enough authority, and the only people that do have authority to give us the ability to come together are the states. We're going to tell Congress what we're doing just as a courtesy, but they don't have any authority on this. And so it's very clear. In fact, you can read a summary of all this in Federalist 40 by James Madison. The states called the convention. The states named their delegates. The states gave their delegates instructions. And their instructions were the purpose of the convention was to render the federal constitution adequate for the exigencies of the Union. That was what they were supposed to do, and that's indeed what they did. And so it's also not true that they illegally changed the ratification process. The idea that it had to be unanimous, the correct source of law for that is not the Articles of Confederation. Remember, we're not operating inside the Articles of Confederation. They were operating under the residual sovereignty of the states. But those same documents that appointed the delegates told the delegates that the process for ratification was to send it to Congress, and all 13 states had to ratify. And so it's the same rule as was in the Articles of Confederation, but it's a different source of law. But that's exactly what happened. Congress approved two things. Approved the new Constitution, and it approved the new process of not using the legislatures to ratify and not requiring 13, but requiring 9 conventions to ratify. But they didn't send it to the ratification conventions. Instead, they sent it to the state legislatures to approve the new process. All 13 state legislatures approved the new process prior to the new government becoming operational. So the call was legal, they obeyed their instructions, and the methodology for changing the ratification was legally done. I have been a church elder many years, and our church elder board has a rule that all decisions have to be unanimous. We could change that rule if we wanted to, but we'd have to have a unanimous vote to adopt a new rule that henceforth all decisions would have to be somewhat, 2/3 majority or something. Well, that's a perfect parallel to what was done here. The rule had been all 13 states had to ratify, but they saw the problem with that, and so all 13 states, Congress and all 13 states, approved a new methodology. So the idea that you can be a constitutionalist yet think that the Constitution was illegally adopted, I submit, is intellectual schizophrenia. That it's like saying that George Washington was a great American president, but he was also a British spy on the side. There are some lawyers are used to arguing in the alternative. Sometimes it's not permitted because your alternatives are actually self-contradictory. And this is one of those occasions where I would hope that all of us in this room, regardless of our perspective on whether it's wise today to use Article 5, would adopt the correct history of this and have faith in the integrity of the Constitution of the United States. But it is that false history that all of us were taught. You go read public school textbooks, you go read scholarly books, you go read anything, except for the original documents themselves. You can find that false history out there abundantly. We need to adopt the true history by reading the original documents and getting the history correct. But all the concerns not all of them, but a good portion of the concerns that arise about the safety of Article 5, using it appropriately, arise from the incorrect belief that we have a history of runaway conventions. The truth is that we've had over 30 multi-state conventions in the history of America, about 2/3 of those before the Constitutional Convention and about 1/3 after the Constitutional Convention. And there's only 2 things that are true about all such conventions. One, it's always one state, one vote. Secondly, it's also every convention is always stuck to the subject matter at hand. Whatever it was, we've never had a runaway convention. The idea that we've never had one of these, we've never had a convention under Article 5, true. But we've had multiple conventions for multiple purposes. And the nature of human nature and so on, the arguments that are raised about why an Article 5 convention would run away are not peculiar to Article 5. The argument arises out of the nature of human nature. And if we have no historical precedent, there is no basis whatsoever for suggesting that we have anything other than a faithful tradition of sticking to our subject matter and one state, one vote. There are three basic reasons, and I've just given you the one, why this process is safe. First is this historically, the historical answer, which we've already visited. Second is the legal answer, and finally I'll give you a political answer. The legal answer is this. There have been 400 plus applications for a convention of the states in the history of the country, and that is the historically correct name. The very first application here ever under Article 5 was by Virginia in 1788, filed in May of 1789 when the government actually got operational. It called it a convention of the states. That is the historical name. A constitutional convention operates outside of Article 5, outside of the Constitution, and it would not be binding on any state that did not agree. And so it's an act of residual sovereignty. So nobody advocates a constitutional convention. And people that insist on calling it that simply don't know the correct terminology and they don't know the correct source of law. And so, again, like the history, we need to get the facts correct. We can make wisdom arguments all we want, but let's get the facts correct. This is a convention of states. And the nature of a convention of states is one state, one vote. It's like international law, in a sense, because it's a meeting of sovereign entities. Sovereign entities, when they meet under the UN or any other basis, NATO, any other basis, it's always one state, one vote. And in international law, nations are called states. One state, one vote. And that's the nature of a convention of states. There is no other possibility of how it can be organized. People like to point to a recent article by the Congressional Research Service that says that Congress thinks that it has a lot of authority in this area. Well, what's the evidence in this Congressional Research Service article is that 41 bills have been filed in the history of Congress where they purported to try to regulate this process. Well, the only thing that's in common of all 41 of those bills is all of them have failed. And anyone that thinks that failed bills create a legislative precedent needs to go back to law school. In fact, the Supreme Court of the United States in Youngstown Sheehan 2 versus Sawyer considered a failed bill in the Taft-Hartley Act and the legal effect of that. And the Supreme Court in that instance said this proves that Congress rejected the idea that the president should have the power to seize the steel mills. So a failed bill, if it creates a precedent at all, normally we would think it does creates no precedent one way or the other. But if it creates a precedent at all, it would create the precedent that the opposite of what the bill purported to accomplish. So 41 failed bills in Congress, if it creates a precedent at all, creates this precedent. Congress has a dramatic history of rejecting the idea that it can control this process. And so the people that argue that, people will say, well, under the necessary and proper clause, Congress can do just about anything. No, they can't. A 1798 case decided by the Supreme Court on this topic rejected the idea that ordinary legislative authority is grounds for Article 5 action. Article 5 is contained by Article 5. And that case, that application, that 1798 case was used in a case I litigated about the Equal Rights Amendment in the late 1970s. And in that case, the court held Article 1 power cannot be used in the Article 5 process. The necessary and proper clause is contained in Article 1. The president has to sign legislation under Article 1, and everyone should know the president has no role in Article 5. And so the idea that the necessary and proper clause is usable here is done by people who have not done the research accurately or like Congressional Research Service. If those people wrote what they wrote in that thing in a constitutional law exam that I was grading, they'd flunk. And so, I would suggest they go read Youngstown Sheehan 2 versus Sawyer and rethink their position. So the legal precedent is this. 400 applications in the history of the Republic. We've never had a convention because we've never had an agreement on the subject matter. James Madison in the first Congress said, when the states agree on the subject matter, when 2/3 of the states agree on the subject matter, then you have a convention. We've never had a convention despite hundreds of applications because we've never had 2/3 agree on the subject matter. The case I litigated under Article 5 on the Equal Rights Amendment, to be sure, is about the ratification process, but it's as close a precedent as we have. On the ratification process, the ruling was you can't change the rules in the middle of the stream. And that's very persuasive precedent for this aspect of it as well. You can't change the rules. When you start off for a convention, in the case of the application that I'm proposing, is to impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and impose term limits on federal officials. That's a rule of germaneness. You've got to have 34 states agree on that rule of germaneness. 3 have already done so, Florida, Georgia, and Alaska. This is pending in a whole number of states right now. It's passed in the House so far this year in North Dakota, in Arizona, and is on its way to passing in many other states. Not going to pass every place this year, but we failed in a few places, but we keep plunging ahead. And so it's actively being in consideration around 20 states at the moment. So when 34 states agree, then you have a convention. The convention legally has to start that way and has to stay that way on the topic. Finally, the political reason that this is so is because 34 states calling a convention for this particular purpose. Let's assume for the sake of discussion that all 16 other states wanted to do something crazy, do something different. Well, first of all, those 16 states would have to get 10 other states who said, no, we're coming here for this purpose, for purposes A, B, and C, to this convention. They're going to have to get 10 of those 34 states to agree with them to go with purposes X, Y, Z instead. And then, at the ratification stage, they have to get 22 of those states to go with them. 22 of the 34 would have to go with them and basically deny what they had just done, said, we want a convention just for these purposes. And I can tell you, I've been in a whole lot of state legislatures on this issue. The states unanimously, whether it's a red state, a blue state, a mixed state, unanimously are insistent that people stick to the subject matter. That's the one thing about Article 5 that is unanimous across all party, state, geographical. Everyone believes that that's the rule and should be the rule. So it's safe. So the final question, and I'd be very brief on this, is this. What problem are you trying to solve? And that tells us what aspect of Article 5 we need to deal with. The charge of this committee is basically to preserve federalism. Federalism, I believe, in this context, is the only thing that's going to save the freedom of this country. Because no government should be the judge of the extent of its own power. Because of the sinful nature of man, everyone wants to aggrandize their own power. And institutionally, the founders gave the states, out of pure human jealousy, the states will be zealous to guard against federal encroachments of power because it takes away their power. They wanted to pit power against power, jealousy against jealousy. And a government that exists where the states have never used this tool is a government that's out of control. And Senator Coburn will tell you more effectively than I can how badly Washington, D.C. is out of control. And so balancing a budget is a good thing. I'm in favor of balancing a budget. I'm in favor of a balanced budget amendment. A balanced budget amendment is germane under our application. I'm in favor of regulatory reform. It's germane under our application. You will not hear any ideas today that are not germane under our application. Every idea that's on the table. But if you really want to change the balance of power and deal with federalism, there's only one alternative, and that's the Convention of States application. That alternative lets you address the real concerns of this committee in a dramatic fashion. If the states don't use the founders gave you the power to regulate the federal government when it abused its authority. And so there's only two choices. Say, well, the federal government's really not abusing its authority, or we want to let them get away with it. If you don't want to let them get away with it, the Constitution gave you a remedy, and I would encourage you to use it. And I'd be glad to answer any questions that any of you have. Thank you so much.
Thank you, Mr. Ferris. And I guess, too, and I know you've got to catch a 2 o'clock flight, so we will keep you. But in the simplest terms, what has to happen, just to make sure we all understand it, in the simplest terms, you have to have 34 states pass amendments or an amendment that are uniquely similar. And once 34 states do that, then Congress is compelled to call a convention of states. Once that convention of states is assembled, each state would send its delegate or delegates, but they would each only have one vote, whether they sent 5 delegates or 2 delegates or whatever it may be. They would assemble and organize, I guess similar to the way our political conventions organize, establish rules for conduct, for seating people. Then they would have debate on those amendments, and then those that were passed by a majority vote would then come back to the states, where 38 states, 3/4 of the states, would then have to ratify it in their legislatures, which could be done either by a legislative vote or by the legislature deferring that to the people for an election. Is that correct?
I need to tweak a couple of points.
Yes, please tweak all you want.
Okay. At the outset, most of the approaches that you're going to hear bills on eventually aren't specifying a particular amendment, but a topic. And so we're setting a rule of germaneness. So the states have to agree in advance on the topic. Now, the topic could be consider exactly the following amendment and quote a text. That's theoretically possible. And that Mr. Dranius is here to explain his approach. He has a precise amendment. He's also got a slightly different procedure that's very creative and unique, but he's proposing a particular amendment. Every other approach that you're hearing is proposing a topic. And at the convention, and so 34 states have to agree on the topic. In our case, it's impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, impose term limits on federal officials. When 34 states agree on that topic, you hold a convention for that topic. If it's for X, the convention is limited to X. So at the convention, you're absolutely correct. It's one state, one vote. And it would be organized like the original Constitutional Convention. That's how they voted there, one state, one vote. So if you have an individual delegate that's messing up, well, as long as you send a handful, that's not going to be, and you also have a method of withdrawing them, it's not going to be that big of a deal because you'll have a majority that will do the right thing. But it's one state, one vote, and then 38 states have to ratify. The choice of this is one of the other tweaks. The choice of the method of ratification is either the legislature, which Congress gets to designate which method. It's either the legislature, and you cannot send that to a vote of the people.
So the Congress designates that, not the convention?
Correct.
Okay.
And so, or it can be ratification conventions. And ratification conventions have been used twice in our history, once for the Constitution itself and once for the ratification of the 21st Amendment. And in both instances, there were popular elections for delegates. And those delegates ran on a, yes, I'm for it, yes, I want to ratify the Constitution, or no, I'm against ratifying, or yes, I'm for the 21st Amendment, or no, I'm against the 21st Amendment. And it was an effective plebiscite on it, but it was formally voting for delegates for that purposes. And so if Congress designated that, then at ratification conventions, the states' legislatures get to choose how you pick your delegates to the ratification conventions. Every state in the 21st Amendment example used popular elections to pick those delegates. The state legislatures chose that. And so you could do that. Now, I would bet any amount of money, and I'm not a gambler, but I would bet any amount of money that Congress will choose state legislatures. Because if the question of their power, the power of Congress, goes to a vote of the people are going to be pretty hard on Congress. I think that they would rather take their chances with state legislatures than letting the people vote on how much power Congress should have.
Members, any questions?
I don't know where to start, Mr. Chairman, so I'm going to pass right now.
You sure?
Yeah.
Okay.
This is all. I'll pass right now.
Okay.
All right.
Good. Mr. Chairman, thank you for the courtesy of letting me go out of order. I really appreciate it. And I apologize for walking out early as well, but I have to catch a plane and get to Arkansas Legislature tomorrow. Thank you so much.
Thank you.
Thank you. Appreciate it.
Chair recall, Senator Coburn. And Senator, just for the record, would you state your name and who you represent?
My name is Tom Coburn. I represent the Convention of States and myself as a citizen of this country. First of all, thank you for the opportunity to be before you. I'd also thank you for your service. I served 16 years in both the U.S. House and the U.S. Senate. I know the downsides of this job, your job. I know what comes with it, and it's not what everybody normally sees. There's a lot of negatives that we don't talk about, and you pay a price for it. So let me thank you each individually for paying that price. Nobody ever thought I'd ever end up in politics. If you went to my high school class reunion, they'd say you're the last guy we ever thought would ever get in this mess. And there's a reason for that. I'm absolutely plain spoken. I have no finesse. I admit that to you today. But I also have a story to tell you that I think is important that you listen to. I spent 16 years in Washington, and the whole period of time there was to have a fidelity to the U.S. Constitution, what it said, what it intended. I've read the Federalist Papers 10 times. I know what our founders intended. And I also, through both my degree as an accountant and as a physician, learned that you don't solve problems by treating the symptoms. You treat the disease, the dis-ease. And our country is diseased. We have a lot of problems. But the biggest problems in front of us are the fact that we're going down the road that every other republic has gone down. So go to history. Tell me a republic that's survived longer than us. Tell me how they achieved their survival. And tell me what the common denominator was that they all failed under. And I would put to you today that we're failing under the exact same common denominator that every other republic has failed. The other thing I know through my experience as a 67-year-old male, being raised in the 50s in this country, is my freedom today is far less than what it was in 1960. Far less. My personal individual freedom. Now, nobody intended to take part of that away. It has happened. And it's happened because the size and scope of the federal government has expanded way beyond anything our founders ever intended for the federal government to be. They intended for you to be the purveyors of justice and the protectors of liberty in your own state. And let me just give you a few examples. We have people who want to propose a balanced budget amendment. I'm all for that. But the fact is Washington's totally dishonest with you when they talk numbers about where we really are. And I'll give you an example. The CBO, as well as the Office of Management Budget, said that our deficit was $420 billion last year. Well, that's an out-and-out untruth. Because if you look at the increase in unfunded liabilities on the books of the federal government, what actually happened is we accumulated about $6 trillion more in excess than what we had. $6 trillion, 1 year. And that's made up of almost $1 trillion in federal employees, retirement and health benefits that's not been accounted for. That you go to the Social Security trustees report, the Medicare, Medicaid trustees report, and you look at all the rest of it, you come up with about $5.6 trillion per year in additional obligations that's going to fall on our children. So I go back to what has been the fall of every other republic. It's been fiscal. It's been fiscal in nature. They all collapsed financially. And there's all sorts of pressures that we get as Oklahomans or Texans and legislators. You get all these benefits of the money that flows from the federal government, but every time it comes with strings. And I used the example several times. I actually had the Department of Transportation actually calculate this in Oklahoma. Is if you had the same amount of money without federal rules on building safe highways in Oklahoma, how many miles can you build versus building highways with federal rules? Well, we can build 1.66 miles of highways using common sense and Oklahoma ingenuity that are just as safe, just as good, will last just as long for every mile we can build using $1 of federal transportation funds. Think about your education fund. Most states, it's not in Texas because you guys are so big and so successful, but most states, education funding is 50% of the budget. How much of that do you control? About 25%. Because all the rest of it's controlled by somebody in Washington with a set of rules that doesn't care about your children, has no knowledge of what your children, has no knowledge of the local or regional implications of what needs to happen in education in Texas. I'd also put forward to you that one of the guys that wrote about our founding, one of the guys that was very involved, also founded the University of Virginia. His name was Thomas Jefferson. And it really was difficult for him to do that It was hard at that time to get a university founded. And he was asked, why don't you go to Congress and get some help? You know, he was well liked. He was president. He could have gotten it. And he said, my young man, you don't understand. For the federal government to be involved in education, you would have to change the U.S. Constitution by an amendment. Well, that's a direct quote from one of our founders. Where do we find ourselves today? The other observation I would give you, for having been 16 years in Washington, is the further away you get from the people, the less common sense there is. And, you know, there isn't a thimbleful in Washington. It isn't there. There's a lot of conflicts of interest. There's a lot of expediency. There's a lot of cowardice. But there's not much courage, and there's not much common sense. And I would just relate to you this following story and then answer any questions you have. Over the 10 years I was in the Senate, I identified in excess of $400 billion of duplication, fraud, or waste. Nobody disputes that number in Washington. It's all still being spent. And I served there under Republican presidents with Republicans under control, under Democrat presidents with Republicans under control, under Democrat presidents with Democrats under control, and under Democrat presidents with Republicans under control. So I've been there in all mix. They're not going to fix it. They lack the courage, the willpower. They don't love our country enough compared to how much they love their job. And what we're seeing is a diminution of your rights to represent your people in the state of Texas and their right to liberty, which we gave to the federal government to form the federal government. They didn't give us, the states. The states gave the federal government its being. And it's time to rebalance that effort. This will be a hard thing to do. Some may not want to do it. But a prediction for you is if we don't do it, we will go exactly the way of every other republic in the history of man. Edward R. Murrow said, history never recognizes difficulty as an excuse for failure. I think our country can cheat history. This wonderful diversity of people that we have, this wonderful mix of ideas, this wonderful genius that comes when you mix all these ideas together with the American effort, we can have another 100 or 200 years of a growing, vibrant, entrepreneurial republic that elevates people and lives no matter where they come from. But only if it's liberty-based and only if the sovereignty of the states is restored to the level at which it should be. Thank you. I'd be happy to take any questions you have.
Members, any questions? I can see it on your face.
Yeah, yeah.
All right.
Yeah. Thank you,
Chair
Mr. Chairman.
recognizes Representative Miles.
Yeah, it was a high fastball. You got it. Senator Carver, let me thank you for your testimony. It was enlightening. And like you, many of my peers probably would have thought I'd be in politics. I just had a couple of questions that I need to ask just for point of clarification. How long have you been involved with the Convention of State Projects?
6 weeks.
6 weeks. How long have you felt the feelings that you expressed today here?
4 years.
How long have you had those?
4 years.
Since the Obama administration?
No. I'm a good
years.
friend of the president's. This doesn't have anything to do with the president. I started thinking this way before President Obama's there. This isn't a problem of a Democrat president or a Republican president.
You give me that fastball
Okay.
again. How long have you felt this way for the last 4 years?
At
you said?
least 4 years.
Last 4 years.
When I kept running up to, I can't solve a problem in Washington.
Right. And you've been involved for 6 months with this organization?
No, 6 weeks.
6 weeks.
Yeah.
6 weeks. Okay. And the last time there was a convention, I think this is probably for the other gentleman that spoke before you that had to catch at 2 o'clock. The last time there was a convention was in, if I'm reading correctly, was in 1787?
89, I think.
1780.
Well, I'm not sure. I'm not the historical expert on this.
My staff has done some research. And
Okay.
if we look at it as 1787.
Okay.
They called a convention. Texas actually called a convention, Mr. Chairman. You probably already know this. 1899.
You was there.
You was there?
Doc would have been closer.
I didn't say that.
Doc Anderson was there. or at least his hat was.
In 1899, and the last one for the country was in 1787. And you really feel that if we continue on the roads that we're going, there will be a Republican that will go down in history as another failure.
Yeah, and let me tell you why.
Please.
We're right now, if you use generally accepted accounting standards, the unfunded liabilities for the federal government, just the not state, for the federal government's $144 trillion. All right, I can back that up.
I don't doubt that.
And there's $18 trillion worth of debt. Now that comes to $162 trillion. That's $500,000 per man, woman, and child in this country. So we now have everybody's future leveraged $500,000 just based on what we owe and our obligations over the next 50 years. And we don't have the capability, given where we're going in terms of our growth, to outgrow that. So how do you solve that? Well, you solve it the way we're solving it now, and every other country in the world's doing it. They're printing money, we're in a currency war, and they're deficit spending. Everybody's doing it. There's not anybody that's not doing it. So what's the outcome of that? And so for us to end up on top, for everybody, means we need to be honest about what our problems are. That we can solve these problems. I'm not saying they're not solvable. But you can't solve them unless you're honest about what they are. OMB isn't honest about them. CBO isn't honest about them. The Speaker of the House isn't honest about them. The Leader of the Senate, and I'm talking about Republicans, aren't honest about it. The President isn't honest about them. Nobody in Washington's honest about what the real problem is. And the real problem is we've mortgaged our kids' future and undermined the stability of our republic by spending money that we didn't have on things we didn't need. And I'm not talking about social programs. We need those. I'm talking about the $400 billion, $100 billion in fraud in Medicare a year, just in one program. And we've known it for 5 years and nothing's happened. Well, I think if you let the states take care of that, Texas legislature would fix that in a year. You wouldn't tolerate it. So why would we allow us to continue down that road? Our children are worth more than that. Our future's worth more than that. Let's cheat history. Let's do what's right. The way our founders gave us a way to fix it. And I don't want to lose our rights. I don't want to give away anything. But I know, as much as I got gray hair today, what's going to happen to us. And I'm a student of history. And I don't see a solution other than us as members of individual citizens in individual states reasserting what is our right under the Constitution to put some control on the federal government.
Thank you.
Thank you.
Representative Clarity.
Thank you, Mr. Chairman. And Senator, thank you for being here today and for your testimony. I very much enjoyed both the knowledge and the history and the experience that you have and bring to bear on these issues. I would like to ask a few questions, though. I hear what you're saying. You don't need to treat the symptom, you treat the disease. That makes perfect sense to me. And I think you've done a good job describing it. And I guess I'm curious with our previous witness, Mr. Farish. I think he identified three fundamental issues or topics he would like to see taken
Areas
up.
of germaneness, I think, is the way he put it.
That's fair enough. One was fiscal restraint on the federal government. I think the second was reducing the jurisdiction of the federal government. And the third was to establish term limits on federal officials. I think I got that correct. First off, do you agree with those being the three areas that need to be addressed if there's a convention of the states? Is that are those the right topics or areas of germane?
I'm not sure I'm qualified to say that. I'm comfortable with that because if you're talking about fiscal issues, you're talking about how much can a regulatory body out of Washington tell Texas to spend on water when in fact there's no health benefit to citizens of Texas? I mean, should there not be a connection between those two? So right. I think with the areas of germaneness, you can go in a lot of places that will help our country become healthier and more economically sound.
Well, and I guess that's my question. I know one of the concerns that opponents of a convention of the states have is the quote, runaway convention. Okay. Those three areas, I would agree with those. And we do fundamentally agree on this. I think our federal government is on an unsustainable trajectory. We cannot keep doing what we're doing. In fact, I would submit to you that I feel my role as a state representative and state legislator in Texas is to make Texas as strong as it can possibly be for what inevitably may happen with our federal government.
Yeah.
I think Texans are always better equipped to take care of Texas. Yeah. And so with that in mind, so I share the same concern, and I don't, what's the classic definition of insanity?
Continue doing the same thing, expect a different
results. Well, we keep doing the same things, and we see some of the problems with the results. But those three areas of germaneness of those topics are very broad, and purposefully so. And I think that's one of the reasons it gives us concern about opening this up to everything, because in many respects, those three areas of germaneness do cover everything.
Well, they really don't.
There are some, as we know, as Chairman King can tell us, there are some artful dodgers involved in the legislative process who are very good at arguing germaneness or materiality or whatever the case may be. And you can drive a 18-wheel truck through any one of these areas and make something germane.
I used to have your exact position.
Okay.
I did, up until probably a year and a half ago.
And tell me when the scales fell off your eyes.
The scales fell off is because we're doing nothing assures us of failure. And I would risk, I don't think there's any chance, zero chance of a runaway convention. First of all, because I trust the common sense of about 15 states in this country that is totally different than what you see in the far northwest and the far northeast. So there's 15 states that are never going to let anything stupid happen in this country. That's number one. I trust that. That's a belief. There's no facts behind it. It's just my trust. The other thing is right now, 69 of 99 legislatures are controlled, legislative bodies are controlled by more fiscally conservative people that would not want to give up those guaranteed rights under the Bill of Rights or other recommendations. So I don't see that as a real thing. Here's my main point, is the fear of something going wrong versus the knowledge of it, we're going down the tubes. I don't think they equate. And our country was built on courage, not fear. It wasn't built on worry. It was built on I can do. It was built on let's get together, let's meet in the middle, let's solve the problems, let's secure our future, let's secure our children and our families. That's what made our country. And what we have to do is get back and reach for that.
And Senator, I do appreciate all that.
Ladies and gentlemen, let me interrupt you just for a second.
Please.
Folks, we are really excited everybody's here today, but we kind of have a tradition of not applauding the witnesses when they're testifying and no hooting and hollering and things like that. So kind of just grit your teeth and restrain yourself.
And I think we have that rule because we're kind of jealous because they never applaud for us. It's always for the witness.
Every time.
But
We worry about the heckling, too.
That's
Mr. Chairman, they can wave their hands quietly. We'll know that you're applauding.
There you go.
That's what you can
There
do.
you go.
We'll know that you're applauding.
But Senator, let me ask you a question and put your doctor hat on.
Okay.
And then when you took the Hippocratic Oath, you were the instruction is first do no harm. And I agree that we have significant challenges to our country, our nation at the present time. But I would submit to you that this republic has withstood more strenuous tests, more difficult challenges to its not just its fiscal health, but to its various existence from the time of the founding of the republic through the war between the states. Through the First and Second World Wars, we have faced many challenges as we move through the potential problems as we have tried to embrace civil rights, and those changes we have met and those challenges very well in this country. So these are serious topics. We want to do it, but I'm one of those few lawmakers that I don't think we judge our success by how many laws we pass.
Oh, I agree.
I think we do our better job when we eliminate laws that we no longer
Yeah,
need.
I always told my constituents you're safe when we're not in Washington. We
That's
can't
right.
hurt you.
That's right. I have many of my constituents who say we're here 2 years every 140 days. They prefer we're here 2 days every 140 years.
Let me give you an example. Just I think it will kind of show you where I am. I have stage 4 prostate cancer. Okay, that's a tough disease.
There's a story on it.
I get to make a choice. I can take some terrible poisons every 21 days, that have a very small but real chance of killing me, real, in hopes that I can cure that disease, or I can not take it at all and know I'm going to die. I think that's where we are. That's my assessment. I wrote a book called Breach of Trust. Now, I've written a couple of books about Washington, but the breach of trust really is about the character of our country and the character of our politicians and the character of our leaders. And the real deal is whether or not we're going to get heat for doing what is in the best long-term interest for the country, even though it might not be popular right now. And I decided when I went to the Senate, nobody wanted me in the Senate. All the Republicans were against me when I ran. Nobody wanted me there. And the fact is I was known as Dr. No, because I actually looked at the Constitution and said, it isn't there. I'm not going to let it go. I'm not going to let it move. And so I got a lot of heat for that. But the fact is I have the highest reelection percentage of anybody ever in the history of Oklahoma. Not because I was right all the time, but because I was truthful and straightforward for how I saw the problems. And so you get elected to see the problems. I can't change your mind on what that may or may not be, but what I can call each of you to do is to have the courage to look into the future to see what the risk is of not doing anything. And I would tell you, in my judgment, it is severe. And we're not a long time away. I'm a great studier of economics. I have spent the last 5 years reading everything I can about economics. I think the world's going to melt down economically in a very short period of time based on what's going on out there right now. And I don't think there's anybody smart enough to stop it. And I think we ought to be ready for that in both our freedom, our budgets, and our country.
Well, thank you, Senator. Let me just finish up this last question. I would just make this observation, and I do sincerely appreciate your testimony and the passion which you've represented your state and our nation and the service you've provided. But as you to carry your analogy that this is like a terminal illness, I think it's prudent on the part of this committee and of all citizens and of all states in our federal government to go seek a second and a third opinion.
Sure.
I want to make sure I have that right diagnosis before I take a potentially fatal medicine. And I'm not saying we don't need to do that. I will tell you, I think I can speak for myself, and I think the other members of this committee, that we are very open-minded in trying to understand these issues. We didn't get here overnight. We're not going to solve it here this afternoon. But we are sincere and earnest in looking at these issues, and I want to hear from many people. I think that, Mr. Chairman, you said there's 3 schools of thought. I think we've now heard from 1. So we're going to get at least 2 more opinions.
You are.
But you make a very persuasive case.
I just make one point. If you
testimony.
don't use the right numbers, doesn't matter whether you pass a balanced budget amendment or not. And Washington has never been honest about its numbers. So if you pass a balanced budget amendment without generally accepted accounting principles, GAAP numbers, you got nothing. And what you really have is disappointing the American public because you ask them to sacrifice to solve a solution that won't give you a solution to the problem.
And Senator, thank you for that. I will tell you, my sitting in front of me on my desk on the floor is Representative Stevenson, who's a CPA, so he's going to be in my ear about this all the time.
Good.
So I appreciate your testimony. Thank you for being here.
Representative Stevens.
I'm not going to talk. I am. And I've spent a lifetime myself, not just being a CPA, but what's the effect that's happening on the country, especially in the tax law. It's amazing. I mean, can't imagine how anybody. I asked Senator Cornyn one time, I was up in Washington, D.C., if I could he would give me a pass to the White House. And I said, I'd rather go to the Treasury. And he looked at me kind of funny. And he said, I said, more preferably, I want to go to where they write those regulations. I just want to meet those people. That's what we have a problem. We can't even understand what the stuff comes down. I appreciate you putting that stuff. It's something that I really strongly believe in financial and general accepted accounting principles, because it works. Numbers don't lie. The liars make numbers. And that's our problem in the country. That's why Texas, I'm going to brag on this because we are the best by far.
You are.
We don't do that to the extent of anybody. Thank you.
Representative Miles.
Yeah, thank you, Mr. Chairman. Senator Carbar, let me also say thank you for the time that you served. And now that I start thinking, I remember a very flattering piece that CNN did on you. a little while ago, and I remember watching that piece and wondering and admiring your words then. But I got to ask you some questions because I'm the double minority on this particular subcommittee, so I've got to ask you a couple of things, just so I can get a right perspective of where we're going and what we're trying to do. Would you agree with me that the deficit is going down? We're working toward getting the deficit down as we speak right now?
No, I would not.
Okay. Is gas prices affordable at this present time?
Are they affordable?
Yeah.
Depends on what your budget is. Yeah,
The
it's
Dow
better.
Jones is breaking records every week.
Yeah, they did in 1929. They did in 2001.
And-
exactly the same thing.
And we're going to have a robust discussion about it, I assure you. And the deficit is shrinking. More people have affordable health insurance at this time.
Yes.
Unemployment is the lowest since before the recession. And the nation is not doing just that bad, are we? Are we really doing that bad?
Yeah, you are. And let me tell you how you measure it.
Okay. Tell me how. Now,
Yeah,
when we
here's
talk
how-
about measuring things, we have different degrees of
Okay,
measuring.
but
Correct.
let's just see if you would agree with this.
Okay.
Median family income, do you think that means anything in this country?
Absolutely.
Okay. We're at the level of 1988 right now. So we are now 25 years. We have median family income hadn't increased in terms of real dollars. In other words, the standard of living is exactly the same as it was in 1988. Why is that? And that's not Democrat or Republican.
I'm with you on that.
That is, we have tampered down. We lost 300,000 businesses last year. The unemployment rate isn't true because the participation rate isn't accurate. Half of the kids that graduated from college last year aren't working in a field in which they graduated. And of those half that aren't, half of them only have a part-time job, and they're living at home with their parents, not because they want to. So have we done better than other people? Yes. Has the Obama administration done some things to make things better? Yes. You know, I'm a good friend of him. I defend him all the time.
I remember that in that story.
And I'm
that
not
you-
liked in Republican circles
I
because
remember
do,
that
but
in the
he's my
story
friend.
that you and him were very, very good friends. He relied on you when it came to economics.
Yeah.
So I remember that part.
So, but the point is you're seeing signals. Go back and study 1929. Go back and study 1987. Go back and study 1999, and you will see the same thing. We have an exorbitantly high PE ratio on forward earnings. The other thing is the bid cover on our bonds. Here's the thing you really need to worry about. It's been shrinking every month that they're issuing new bonds. All right? That's the number of bids versus enough bids to cover the auction. What happens the first month when the bid cover ratio is less than 1? It doesn't matter what the Federal Reserve does then. That's what the world's saying our interest rate's going to be. The Federal Reserve isn't going to control it anymore. So the time for us to be acting is before the rest of the world controls us like we've been controlling the rest of the world. We are the dominant currency. And had we not had a rising currency, we'd be seeing greater growth than what we have right now. But we also, there are some things that are going on in terms of the Middle East and the price of oil that's been manipulated that have long-term benefits to the Middle East and long-term deficits to us.
So one more last question, Mr. Chairman. I'm sorry. And so you think that state governments, with the exception of the great state of Texas, for which we're in, you think other states the other 49 states can do as good as a job as, or better than the federal government?
Oh, by far. By far. Yeah, I really do. And here's why. They're not smarter. They're closer to you.
Yeah.
You know,
Well, we always say politics is local. We always say that.
well,
That's the term we
it's
always
not
use.
even politics that's
So-
local.
so-
It's about hearing
hearing
what
the people.
people think. I got to 20,000 letters a month. I read every one of them as a U.S. Senator. I was the only senator to do that. I wanted to know what they had to say. That's what kept me close and connected. That's hard to do. It's even hard for you to do in a state as big as Texas to read every constituent letter. The fact is, the closer we know this by history. Our founders even said, the closer the government is to you, the more effective it's going to be and the more liberty you're going to have. And so it's not, I have Coburn's rule of bureaucracy. And I observed this while I was in Congress. Here's my observation about federal bureaucracies. It applies to states too, but not near to the degree. Never do what is best when you can do what is safe for the bureaucracy. And I've seen that 100% in action, and you have too in the state of Texas. When some common sense decision could have been made, it wasn't. because we're afraid we might embarrass or we might expose the bureaucracy.
That's correct. And let me say this. We live in the great state of Texas, but nobody's perfect.
I agree.
Unfortunately, not even Texans. We're not even perfect. But we work hard at perfecting and correcting the wrongs.
You're one of the greatest states in our country.
That's what makes us different from
Yeah.
other states. We work hard at perfecting our wrongs.
Yeah.
I've enjoyed it.
Thank you.
Thank you.
Mr. Chairman, thank you.
Members, any questions? Representative Parker.
Thank you, Mr. Chairman. Senator, thank you for being here, and we're honored to have you, and just appreciate your service to the country, and you're in our prayers and your personal
Thank you.
struggle, and so thank you very much for sharing that and being very open and candid with us. I found it to be very compelling that you were where many of us have struggled on this issue, and you talked about a year and a half ago the fact that you weren't supportive of this movement, so to speak. And I think we've ideological alignment on all the things that we discussed today, be the fact of runaway government spending, all the issues, the great concern. I've had some economic training in my life as well about the dollar losing its position as the reserve currency of the world. I think is very concerning to us. But you're obviously taking one path, directly going towards the Article 5 convention. I guess my question is, do you see any other path that the Congress can take, obviously driven by the hopes and the actions of the American people, to resolve this short of this? I want to get your perspective on, if you wouldn't mind.
It's a
giving us your
bold, blunt
thoughts.
perspective, and it's not very well appreciated in Washington. But my solution is fire everybody that's up there and send somebody who's had real life experience across the board and reelect everybody new that's in Washington, no matter what their party is. But not another career politician goes to Washington, because the personal conflict of getting reelected versus doing what's in the best long-term interest, it is always there. And the only people it's not there is the ones that don't even give a flip about being there and don't care whether they're called senator or not. And so that's a rarity in Washington. So the American people could do it. They just haven't. And because we have a system where incumbency is so advantaged in this country to where you can hardly defeat an incumbent. And they may be great or they may be lousy. So the real deal is, can you fix this a different way? Yeah, change everybody that's in Washington, that's in elected office, and with the mandate, go clean this government up. Get rid of the $420 billion worth of waste, fraud, and duplication. Get rid of the $100 billion worth of fraud in Medicare. Change how the agencies work. Why is it that the average federal employee retires at a minimum of $75,000 with paid health insurance, not on Medicare the rest of their life, with the benefits higher than anybody else in this country, even some corporate position? And why are we spending $1 trillion a year to try to afford that? And why is it that we have more federal policemen than we have U.S. Marines, when in fact there's not supposed to be the first federal policeman? I mean, those are some questions we need to be asking, and we're not asking them. So I think that there are other ways to do it. I just don't think they're going to happen. And I, quite frankly, I left there discouraged, because I beat my head against the wall for 10 years and got really, other than eliminating earmarks, nothing done.
And in your 16 years, roughly, of service to the American Congress, up until a year and a half ago, you were opposed to this concept.
Well, I hadn't really considered it. I've been working. I said, surely I can convince my colleagues. Surely when they see this fraud, surely when they see that there's $65 million a year spent in the Pentagon that doesn't have anything to do with defending the country, surely common sense will say they'll change their mind.
Yeah.
Well, guess what? Lobbyists have more power than common sense. And careerism has more power than common sense. So I think the way we restore the balance between the states and the federal government, and we put the federal government back in the position it was intended to be, which all our founders wrote about to get the thing approved in the first place, is to have a convention of the states that will actually do it.
Senator, again, thank you for being
Thank
here.
you.
Whatever decision we ultimately take here in Texas, we're honored to have you here, and we appreciate you very
Appreciate
much.
it.
And again, our prayers and thoughts are with you. Thank you.
Yes, sir. Thank you. Thank you.
Thanks, Senator.
Mr. Chairman, thank you.
Thank you very much. All right. All right, Chair calls the first witness, no, it's the third witness now, Nick Dranius from Compact for America. And
It was 60 minutes or CNN? It was 60 minutes.
Nick, he step out. There we go. And let me encourage you, and thank you for being here. But let me encourage you to the greatest extent possible, stick to nuts and bolts, because I think all of us are trying to understand this from the ground up.
I'll do my best.
Great. In other words, don't presume we have any idea what you're talking about.
We don't.
Well, you're making a presumption about what I know. But, Mr. Chairman, members of the committee, let me just briefly introduce myself. I'm Nick Dronius of Compact for America Educational Foundation, which is based in Houston. I'm the president and executive director. I work with Chip DeMoss, whose father, Harold DeMoss, is a senior judge on the Fifth Circuit Court of Appeals. Chip is a CEO. He has equal power with me. We run it like a Roman republic. Neither of us can do anything we want on our own, and that way there's never going to be any problems with cult of personality. So even though I'm speaking, the reason why I'm speaking is I've been an attorney for 19 years, focused in constitutional law for 10 years. I brought one case to the U.S. Supreme Court and won it, challenging Arizona's clean election system. The element of the case that is pretty unique to have done was to secure an emergency injunction from Justice Kennedy before the case was accepted for cert, which has only happened in civil cases about a half a dozen times in the history of the court. I used to work for the Institute for Justice as a constitutional litigator for 3 years. And I say this not to puff myself up, but just to tell you that the product you're about to hear, the reform idea you're about to hear, is representing the cutting edge of constitutional law and theory. It represents what some folks call Article 5 2.0. And the reason why it's so important is it's designed in particular, Mr. Chairman, members of this committee, to address some of the concerns specifically that have been raised in this committee today. For the first time ever, you have an Article 5 approach that answers every question involved in the process up front. It does nothing until 38 states join in an interstate agreement adopting all of the procedures in advance. It does nothing until Congress calls the convention in accordance with that agreement, so that you have simple majorities of Congress and supermajorities of the states all agreeing in advance and within 7 years of the first enactment, because it sunsets April 12, 2021. So you have real political will, reputation, stakes, clarity, boundaries, law, all lining up behind what this is attempting to accomplish, which is the maximum safety anything in law or politics could ever have. Now, before I go into the details of the process, let me tell you about the payload, because also what's unique about the compact approach is because you use a solemn sovereign agreement between states, you can agree upon the text of the amendment or amendments in future compacts that you're going to propose. And the text of this compact is extraordinarily powerful and effective and yet nonpartisan. And before I get to it, I want to emphasize nonpartisan because there is a gentleman in your legislature, Chairman Richard Raymond, a Democrat, I hear, who for 15 or more years has been advocating a balanced budget amendment in this legislature. 15 or more years. And I had the honor of meeting him yesterday. And he reminded me that there was a senator named Paul Simon, a Democrat from Illinois, who joined arms with, I believe it was Senator Bob Dole, to try to have Congress propose a balanced budget amendment in the late 90s, and they failed only by one vote. So there was a time in this country where there was no partisan dispute over the need for a limit on borrowing capacity, over the need for government to not have the illusion of unlimited resources that borrowing allows in order to function well. Whatever you decide government should be doing, how does government ever function well? How does it not waste, have fraud, have inefficiencies if it thinks it can spend whatever money may ever be needed? I mean, think about the way the government operates at the federal level, and indeed most places right now that have unlimited borrowing capacity. They appropriate whatever they want to spend without a thought to where the money's coming from. This is a function of unlimited borrowing capacity, and it will always lead to waste so long as it exists. Now, some folks say, why mess with the Constitution? Well, I rely on the great words of William Arthur Deming, who famously has designed so many different ways to make efficiencies work in the private sector. Now, Deming said that every system is perfectly designed to get the results it gets. Our system is perfectly designed to leave the mess of fiscal irresponsibility that we currently see. Sadly, it is true. Because the founders made a mistake in addition to slavery. The mistake they made was giving the federal government unlimited borrowing capacity. And the reason why this is such a fundamental mistake is only unlimited borrowing capacity makes it possible to get all the benefits of spending or even unsustainable tax programs today and shift the costs to the future, to our kids who have no vote. There is no effective political check that can constrain the abuse of that degree of power. And if you look across history, in any country that has it, it leads to collapse. And if you look at the chart on this document that I'll hand out after my presentation, and you can see it, the trend of the debt today is exponential. It's not self-limiting. It doesn't matter if you adjust it for inflation or not. It is out of control, and it can go no other way. How else could the debt be if you can borrow at no immediate political cost? What stops people other than a government of angels? And we wouldn't have government if we had a government of angels. So this fundamental flaw in our system is what's producing the situation we see. We've already heard the details of fiscal policy. But just to give you the pedigree, I know that I handed out some PowerPoint slides, and hopefully they're in your packet. But the second...
members, you've got them. They should, well, they're under a tab with Mr. Dranius's name.
As you hunt for those slides, let me just direct your attention when you get to it to the second page, which shows a picture of of Thomas Jefferson with sunglasses. We added those because Thomas Jefferson understood this 200 years ago. Listen to what Thomas Jefferson said about the Constitution. He said, "I wish it were possible to obtain a single amendment to our Constitution. I would be willing to depend on that alone for the reduction of the administration of our government to the genuine principles of its Constitution. I mean an additional article taking from the federal government the power of borrowing." What Thomas Jefferson understood just 8 years into the whole program, maybe 9, was that if you don't limit borrowing capacity, if you allow unlimited borrowing capacity, there is no parchment barrier that will stop the federal government from growing, because there is no way you can politically sustain a limited government when your opponent is saying, "I'll give you anything you want at no cost." And that's what we've seen. So how do we fix this problem? This is the solution we have in the compact. If you go to the next page, you'll see the essence of it. Our balanced budget amendment does most of what Thomas Jefferson hoped for. The truth of the matter is TJ was a little aggressive in saying get rid of all borrowing capacity. But we do need a limit on borrowing capacity that brings home the reality of scarcity and resources to government. So we propose an amendment that has a debt limit constitutionally fixed in a way that cannot be gamed. How do you do that? You limit spending at all points in time to cash on hand, not to estimates, not to budgets, not to accounting principles, but to cash on hand. Now you're probably going to say, how do you make that work with tax flows being volatile? It's not hard. You have a line of credit. You use the line of credit to handle the volatility in your cash flow. So your only exception from spending cash on hand is to borrow from a revolving line of credit. So ironically, the amendment does provide for a large revolving line of credit for the federal government. That revolving line of credit is fixed constitutionally at 105% of what's outstanding on ratification. What does that mean? Say we ratified this with $20 trillion in the national debt outstanding. The line of credit, the revolving line of credit, would be $21 trillion. It could be paid down in good times, leaving borrowing capacity of amazing proportions for bad times. And just in case you thought there might be a national emergency that required more borrowing capacity than $21 trillion managed responsibly, we even provide for that flexibility. But we do not leave that flexibility in the hands of the debt addict. We've learned from most school districts around the country that you need to have external discipline before you engage in borrowing. And so the process of external discipline for any flexibility in this debt limit is a referendum of the states within 60 days approving or disapproving any increase in the debt limit. We reintroduce the states as a source of direct external discipline on national policy making, and we target it to a clear, nonpartisan problem area. restoring a portion of what was taken away from the states in the 17th Amendment. Because if you may recall, there was a time when external discipline was part of our system at the federal level. The states controlled the U.S. Senate. That means the states controlled not only borrowing policy, at least half of it, but spending and taxing and regulatory policy. And not only that, but treaties and appointments. When the 17th Amendment removed the states from a position of control of the Senate, it eliminated external discipline from that system in Washington. And lo and behold, that concentrated power has been abused. We don't concentrate power like that in most school districts in most states. So let's reintroduce the states into a role of oversight and intervention in the debt. And not with an impossible hurdle. We'll win some and we'll lose some with 26 states being required to approve any increase in the debt. You can see that with the Medicaid expansion, and you can see that with the healthcare exchange expansion. But think how differently the mentality would be in Washington if they had no guarantee that they could write whatever credit limit they wanted. Or that if they were going to get any credit limit increase, they'd have to actually persuade folks like you in states that are familiar with balanced budgets. And they would have to do so fairly quickly. Think about how radically that would focus the mind in Washington to finally develop a budget. Because in the end, you can't prescribe budgets if there's no reason to have one. You see, if you have unlimited resources, why would you ever have a budget? I mean, think about it. It's an artifact of habit that the federal government continued with a budget until 1997. I mean, what's the point of a budget if you appropriate whatever you want and don't worry about the costs? It's amazing it lasted as long as it did. And it will never return in a meaningful fashion if you think you can spend whatever money you feel like. Why have a budget? The first step to a budget, let alone a balanced budget, is scarcity and borrowing capacity. And this would attain that, even if the states stood firm only half the time. Now, you'll probably say, well, what do you do about the games of chicken that we see in Congress? And it doesn't matter who the president is. And what I'm talking about is the debt ceiling debate where you've got some guys shutting down government and other guys holding grandma's Social Security check hostage. And some gals involved as well. It's not hard. You deprive everyone of their leverage. You force that debate to take place months in advance of hitting the debt limit. How do you do it? Here's how the amendment does it. You require the president to designate what spending he will delay at 98% of the debt limit, at hitting a red zone. Currently, that would mean $400 billion more borrowing capacity left. That would mean 9 to 10 months before hitting the debt limit. The president would have to designate what he's not going to spend money on and in what priority if the debt limit is maintained 9 months out. Then you give Congress a real countermeasure. Because right now, Congress has no countermeasure when grandma's Social Security check or veterans' benefits are held hostage, other than to accede. Why? Because the only way Congress can respond to the president's threat today is to repeal or redirect the appropriation, which requires whose signature? The president's. So he doesn't give it, and they know it, and so they give in. Our amendment gives Congress the ability to override the impoundments proposed by the president within 30 days with simple majorities, with no presidential signature, using the vehicle of a concurrent resolution. Now imagine the difference in the debate we would have over the debt if 6 to 9 months before hitting the debt limit, both sides had their cards on the table in terms of their spending priorities like this amendment would require. Not only would the looming fact of resource scarcity be hanging over their head, but the reality of numbers, half of the numbers you need for a budget would be on the table. This is a prescription to fix the debt. Now, lastly, the Balanced Budget Amendment has a tax limit. Now, mind you, we were cognizant, developing it and vetting it across 16 think tanks, across dozens of experts, across numerous folks involved in politics, including center-left groups like Third Wave. We were very cognizant that a tax limit can be a deal killer on the left. We were also cognizant that not having a tax limit with a balanced budget requirement or a debt limit can be a deal killer on the right. The right doesn't want to have deficits closed by egregious taxation. The left wants the flexibility of new revenues and not just spending cuts. How do you resolve that dispute? Because, again, we're going for 38 states, the number for ratification. You got to find a way to accommodate both sides and do it in a way that preserves principle for both sides. Here's what we propose. You have a general rule of 2/3 of each House of Congress for income or sales tax increases. That's pretty strong, a pretty good give to the right. But then we create 3 exceptions completely replacing the income tax with a sales tax, end user sales tax, not a VAT, with the current rule of simple majorities, eliminating any exemption, deduction, or credit in any tax code with simple majorities, closing loopholes if you're on the center or left, or flattening the code if you're on the center right. And then lastly, new or increased tariffs or fees, what the founders actually intended the federal government to actually run on. With these three exceptions, you preserve the flexibility in revenues that most reasonable people at the center and the center left will recognize means a lot of potential money. But at the same time, think about the difficulty of actually accessing those three simple majority exceptions. You'll run headlong into some of the most powerful special interests in Congress. Think about it. Who's going to be there to defend the distinction between capital gains tax and ordinary income, or the homeowner's deduction, or to preserve the current tariffs, or to keep from us switching to a national sales tax? These are powerful special interests. And so what does that mean? What is this dynamic that this amendment creates? The amendment makes spending reductions look a lot more attractive. And so we accomplish what our polling data says the American people across the board, across the aisle want, which is spending reductions to close deficits first before revenue increases. That's the amendment. It's spelled out, it's drafted, it's been poll tested at 61% to 81%. It can get to 38 states. So the question is, why use a compact? Why not just wait for the Convention of States to organize or some other Article 5 approach? And Mr. Chairman, I'd go into that section right now, but I don't know how much time I have left.
You don't have any, so let me. But we want to hear this, I'll tell you. Generally, when we think of compacts, we think of the states coming together, and we have interlocal agreements. We have agreements with adjoining states for emergency response compacts, and understand that the compact process works where as many states could agree to particular things that they wish to, and that actually kind of bypasses Congress. Congress gets to vote up or down on it, and the president doesn't have veto authority. So that's what I think we usually think of with compacts. And could you really just kind of give us nuts and bolts of what this looks like?
Mr. Chairman, members of the committee, the great thing about the compact is everything that states do in the amendment process from Article 5 is spelled out in advance in a binding sovereign agreement. And like any other compact, when states agree to that agreement, it's binding constitutionally under Article 1, Section 10, where states are prohibited from impairing the obligation of contract. So you bring a degree of certainty and safety to the process that no other approach can afford. Equally important, any member state can enforce these obligations. You know, one of the problems if you don't have a compact is if you limit your delegates, what stops another state from not limiting their delegates? So a compact solves all of these questions of control over the process and understanding it in advance. Now, like any other compact, that means states have to join it identically. Alaska and Georgia have joined it. They've formed it. We have it moving in 12 states, all including Texas, that have identical language to adopt the compact. The compact itself does nothing substantive other than organize a commission, not a convention, a commission to oversee the process until Congress passes a resolution, which is already drafted and already sponsored by more than a half a dozen people in the House, passes a resolution to activate it. That resolution that is already drafted, already vetted by CRS, and already ready to be introduced in Congress and perhaps also the Senate, only requires simple majorities of each house. It's a concurrent resolution that does not need to be signed by the president. It combines into one resolution both the call for the convention contemplated by the compact and the selection of legislative ratification, which is contemplated by the compact. So the nice thing about this resolution is you can pass it with simple majorities, get in and out of Congress, never have to return, and the entire fight for this amendment turns to a battle in 38 states, 36 remaining. And believe it or not, even though we just got this process started last year with only 36 states left to get the job done, we're ahead of efforts that have been around for 40 years because they still have at least 10 more states to join up in their application on the front end, and they still have to get 38 states to ratify it on the back end. So with this Article 5 2.0 process, 38 states joining one compact with one bill, one resolution in Congress with simple majorities and no presidential signature, one 24-hour convention voting up the amendment or down, and you get it done.
Members, any questions? Great. Thank you very much.
Mr. Chairman, thank you.
Members, we've heard the Convention of States and also the compact agreement approach. This last is the chair would call Mike Stern from the Balanced Budget Amendment Task Force. Mike is the director of Point of Order, a website dedicated to congressional legal issues, and he writes and works on a variety of matters related to Congress and the legislative process. He's a member of the Balanced Budget Amendment Task Force. And as I mentioned before, we already have bills filed on all three of these areas. Mr. Stern, for the record, would you just state your name and who you're here today representing?
Thank you, Mr. Chairman. My name is Mike Stern. I am a former lawyer for Congress, and I am associated with the Balanced Budget Amendment Task Force, and I'm here on their behalf as well as myself as an individual citizen. I will be on the brief side. I think many of the issues that I wanted to cover were covered by the earlier speakers. I appreciate, by the way, the opportunity to follow Dr. Coburn. That's a very easy task for me. But I just want to emphasize the sort of the black letter law of the Article 5 Convention, just so we're clear, because there are some areas of disputes that people have about the Article 5 Convention. But there are things that are actually just in the text of Article 5 that really no one does dispute. And I think that we spend a lot of more time talking about what we disagree about without thinking about the things, the actual part of Article 5 that everyone agrees on and what it actually means. So let me just go briefly through the sort of very basic steps of the Article 5 Convention. The first thing to remember about the convention is it has nothing more than the power to propose an amendment. That is the same power that Congress has every day that it's in session. Nothing more than that, the power to propose an amendment. And the reason that the framers put the Article 5 Convention into the Constitution was that they understood there were some types of amendments Congress would not propose, namely those that reduced its own power or protected the interests of the states versus the federal government. The authority to initiate an alternative method of proposing constitutional amendments was therefore given to the state legislatures. But it's no greater than Congress's authority, and in fact it's subject to even more checks and balances than Congress's authority, so that the notion of this runaway convention is really virtually impossible. So step one is that 2/3 of the state legislatures must apply to Congress for a convention for proposing amendments, which means, as we discussed earlier, 34 states must agree that a convention needs to be called and the subject matter on which the convention is to be called. A state could apply for a convention without a limitation, without any specified subject, but no one is suggesting that any state do that, and that really is not an issue. Step two is that Congress has to call the convention. That means that it has to find that 34 states have in fact submitted ballot applications and that they agree on the subject matter of the convention. By calling the convention in response to these 34 applications, Congress necessarily agrees that the convention can be limited. Why? Because if they thought that the applications for a limited convention were invalid, they wouldn't call a convention. If you apply for a convention solely for the purpose of say a balanced budget amendment, and Congress decides in its wisdom that you can't limit a convention that way, then Congress will not call the convention. They won't call the convention and then say, well, it's an unlimited convention. That makes no sense, and there's really no one who argues that they should do that. That would just make no sense.
What makes them do it anyway? So let's say that you have 34 states submit applications, and they're similar, and they go through whatever court fights to agree to prove that they are similar. And then Congress just says, we've received the application. What makes them actually convene the Convention of States?
Well, that is a very good question. So the answer is nothing really, other than the power, the organized power of the states to embarrass Congress and force them to call it will ever do that. I think, and that's a very important point, because I think a lot of people think, well, if we pass an application here in this state, and then it's sort of like an automatic pilot to we're not sure exactly where, but it's not like that. I don't believe it's like that at all. I think that we now have 25 states that have passed a balanced budget amendment, right? In Texas, actually, is one of them. I understand you're considering doing a renewal, which I think would be a fine idea, but it's not actually absolutely necessary. But 25 states, so we're 9 short of having the 34. But I don't believe that getting the 34th state is going to make Congress turn around like this and call a convention. Now, there's a lot of work that's going to need to be done in the interim, and in terms of educating the American people on what's going on, how this convention is going to work. That is why, as I'm sure you know, Mr. Chairman, there is an effort among state legislators around the country to organize themselves in the Assembly of State Legislatures to start talking about what are the rules of the convention, what are how is it going to work, and to start putting some actual bones on this process, so that when it comes to the point where Congress has to act, there are people who say, okay, we've thought about it. This isn't just something that we say. There's 34 and then we go away and leave you to your own devices. We know what we want, and there's an opportunity in that process, I think, for the states to think about whether they want to sort of try to agree in advance on a more specific amendment, or do they want it to be? Do they want to agree sort of informally? This is the best balanced budget amendment. We're not going to propose it, but we're going to instruct our delegation that this is what they want.
And I don't want to interrupt you, but since you're the last witness, I want to make sure I kind of get my questions answered too. So there's nothing that would actually force Congress to do it, but the theory is that if 34 states take similar action on something, that's going to be very compelling to the Congress to respond to it.
Well, I mean, the Constitution is very clear that Congress is required to call the convention. But
So
when you say
theoretically,
who's someone going to force them, is someone going to?
So theoretically, if 34 passed it, then could a state or anybody with standing, could they file suit and seek a declaratory judgment and a mandamus or something to direct Congress to go ahead and call the convention?
Well, yeah, well, certainly they could. There's no question they could do that. Now, the next question is, what would their chances be of prevailing? Now, I'm going to have to step out of my capacity of representing the Balanced Budget Amendment Task Force, because this is a very difficult issue. I will tell you, as a former lawyer for Congress, I will tell you that there has never been in the history of the United States an order from a court to Congress, directly to Congress, to do anything. Now, there's some cases which somewhat achieve the same effect by ordering officers of Congress, like in Powell v. McCormick, where they ordered the sergeant at arms to reinstate.
But this issue, this question, and I don't want to have to dwell on too long, but this question of how you compel the Congress to act in response to the calls by the state, that's something that's indigenous to all three of the approaches, whether it's convention of states, balanced budget, or compact. All three of those are going to face that problem at some point. But I guess, and just to summarize real quick, your thought is, and I think of the others that testified too, is that if it gets to that point, there's going to be tremendous pressure on the Congress to respond to the state's initiative. Is that correct?
I believe that is your best bet.
All right.
And that is really what's likely to happen.
Great.
And it's going to be a negotiating process between the states
and I guess,
Congress.
frankly, you'd probably see that in congressional elections. Will you or will you not agree to?
Absolutely.
Right. Okay.
Absolutely. So I was on. So the next step is step 3, which is the convention must assemble and debate and discuss proposals, and ultimately decide whether or not to propose an amendment. I don't know if we've discussed today the fact that I know we discussed that it would be one state, one vote. It will be up to each state to decide how its delegation is to be selected, and in that process, you have the opportunity to put some parameters on your delegation, to give them instructions, for example, as to what types of rules they should vote for during the convention, what kinds of amendments you would like to see them vote for, and to prohibit them from voting for anything outside the scope of the convention itself. Now that's a sort of a belt and suspenders approach, because as I'm going to argue here, even if the convention were to vote for something outside the scope, it will be invalid and it won't make it through the process. But many states want to make sure that they have particularly those members who are worried about this idea that the convention could run away, it might go into areas that you don't want, so you can
theoretically,
put limitation on your delegation.
If you did have a convention of the states, and presuming they would each, as they did in 1787, send 2 delegates from each state, and if they did go outside the scope of the resolutions that have been passed by the 34 states, then I'm presuming there would be a real quick court challenge to block that from being sent out for ratification because it had stepped outside the bounds of Article 5?
Well, so before the convention actually proposes something, you have the possibility. I mean, it's not going to happen out of the blue, right? Somebody would have to propose in the convention, would have to draft an amendment that is outside the scope of the call.
So let's say it was a balanced budget amendment, and they took up a Second Amendment related amendment.
Right. So let's say that happened. Then each delegation has, before you get to the convention actually acting as a body, each state has control over its own delegation. So and I believe that there is a Delegate Limitation Act here that may be considered. So under those acts, which have been so far passed in 6 states, the legislature says that if a delegate votes for or votes to consider an amendment is outside the scope of the convention, then that delegate can be recalled and replaced. And also, usually they say that their vote is void. And there's also the possibility of having penalties on them if they knowingly. And obviously, there can be issues where reasonable people could differ, right? I mean, you could have a hypothetical, but in your hypothetical, it's just clear. It has nothing whatsoever to do with the subject matter of the convention. And if a delegate were to violate his oath by voting to consider such a amendment, they could be penalized. And it's similar to legislation that has been adopted in many states for presidential electors who were to vote differently than what they promised that they would vote
for the Electoral College.
For the Electoral College, exactly. So that would be a mechanism that applies even before you get to the convention actually proposing something. And it seems to me that when you consider what Dr. Ferris said earlier, which is you've got 34 states already that have proposed the amendment, that applied for a convention for a limited purpose, it's highly unlikely that any of their delegations are going to be interested in going outside the scope of that to begin with, even if you didn't have any kind of penalties. Then when you put on these acts that penalize any delegates who actually were to try to do that, the chances of that actually happening are very slim, just as very few, even when they were legally free to do so, only a handful
members,
of...
What he's referring to, and forgive me, it may be clear to everyone but me, but what he's referring to is a number of states, and we'll be looking at a bill like that at some point too, but a number of states have passed statutes that simply said, in the event we ever have an Article 5 convention now or 50 years in the future, here's how our state selects its delegates, and here's how we control them while they are in convention. Here's how we recall them, negate, void their vote or their actions if they step outside what the legislature directed or authorized them to do. And I think Indiana and Tennessee and a number of other states have passed something like that too. I'm sorry, didn't mean to interrupt.
That's correct. No, thank you very much. So that's stage 3. Now, let's say hypothetically that despite what we just described, the convention nonetheless somehow proposed something outside the scope of what they were called to do. You still have step 4, as we were discussing earlier. Once the convention proposes the amendment, it doesn't automatically go to the states for ratification. It has to go back to Congress, because Congress has to decide the method of ratification, whether it's going to be state legislatures or state conventions. Now, if Congress believes that the amendment that has been proposed is invalid, right? Let's say that it wasn't adopted. I mean, there are lots of ways, and theoretically it could be invalid. Let's say that there wasn't a real meeting of the convention, or it wasn't passed by a majority. It was, passed in the middle of the night when there was no quorum. Or there are a lot of questions that theoretically come up about a proposed amendment. Congress is not going to automatically send every amendment on for ratification. They're going to insist that it be a valid amendment. Now, if Congress has called a limited convention, and the convention has clearly exceeded, in the hypothetical, clearly exceeded those limits, well, Congress has no reason to view that as valid, because they violated the whole understanding of the convention that it called in the first place. Now, some people say, well, supposing between the time that Congress calls the convention and when the convention actually submits the amendment to Congress, the makeup of Congress changes, right? And now a majority of Congress now believes that the convention can't be limited. And people actually raise this scenario, which doesn't seem all that likely to me, but let's just say hypothetically this could happen. Even in that case, Congress would not, certainly should not, be submitting the amendment for ratification, because if one believes that the convention cannot be limited, then they never should have called the convention in the first place. Those people who believe that in the unlimited convention think that Congress made a mistake in calling the convention in response to the 34 limited applications, and so they have no reason either to submit this out-of-scope amendment to the states for ratification. And then, of course, finally, well, before I get to that, and then besides that hypothetical, people say, well, maybe Congress doesn't really care about the legality of this. They just like the amendment. There's been a runaway amendment, and Congress really likes it for some reason, right? So they don't care that the law says, they don't care about logic or law or any of the points you just raised, Mr. Stern. They just want to do this for some reason. Okay, well, I think that argument overlooks 3 points. First, the whole point of the Article 5 Convention, as we discussed, is that to circumvent Congress. So it's very unlikely that it's going to propose amendments that Congress is going to love. Second, if an amendment really were that popular, Congress could just go ahead and propose it on its own. It doesn't need the convention to propose an amendment. Congress has the power to propose amendments now. And finally, if Congress were to submit an out-of-scope amendment for ratification, then it would still be subject to challenge in the courts. And so for all of those reasons, the idea that the convention is going to try to push the boundaries of its jurisdiction to propose something with all these barriers in front of it, it really just makes no sense. And finally, the last step in the process, of course, is even if somehow it does get through Congress, it gets through the convention, it gets through Congress, it goes to the states for ratification, you still need 38 states to ratify this amendment. And that is a very high bar, as it is for every constitutional amendment. So the idea that any amendment that is viewed as being illegitimate is going to be able to clear all those hurdles is just, I believe, really fanciful. So if I might just briefly close on an issue that I haven't heard here too much today, but in talking to Article 5 opponents around the country, I hear a lot and may come up later. Article 5 opponents often talk about the idea that the federal government doesn't obey the Constitution now, and therefore why should we think that this is going to, they won't obey this, so why do anything? Right? That's an argument that we often hear.
And I know I took up a lot of your time asking questions, but we're just about out of time.
All right, then let me just very briefly finish. The framers knew that human nature would cause those in the national government to accumulate more and more power for themselves, including the power to spend unlimited amounts of money. And they put the convention into Article 5 precisely because they didn't trust the federal government to obey the Constitution, and they wanted the state legislatures to be able to act as barriers to the encroachments of the national authority, as Alexander Hamilton put it in Federalist Number 85. So saying that you don't want to use Article 5 because the federal government doesn't obey the Constitution is like saying you don't want to use a fire hose because the building is burning. It really makes no sense. And so with that, Mr. Chairman, I will close, and if anyone has any further questions, I'd be happy to answer them.
Good presentation. Members, any questions? Great, thank you
very much.
Good. We have 2 witnesses left. We've heard from people on the three strategies here. The next witness on your agenda shows to be Pat Carlson from Eagle Forum. But Pat, if you don't mind, I'm going to let Roman Bueller go first because he's got a plane to catch.
No, that's fine.
Is that fine? Are you okay on time?
I'm okay.
You sure?
Absolutely.
All right. Pat, Chair calls Pat Colson. We've only known each other like 25 years. Pat Carlson, she served as the statewide president of Texas Eagle Forum from 2009 to 2011. In addition to serving as president of the Texas Eagle Forum, she has also been actively involved in the Republican Party, serving a variety of significant roles. And Pat, would you please, just for the record, state your name and who you're here representing today?
Yes, I'm Pat Carlson, representing Texas Eagle Forum, and I appreciate the opportunity of being asked to testify. And if you'll indulge me and let me read, and then I'm going to add.
That'd be just fine.
That way I can keep my train of thought. Never in the history of the United States has there been a convention convened by Congress to amend our Constitution by application of 34 state legislatures, as instructed in the second half of Article 5 of the U.S. Constitution. And Texas Eagle Forum believes this is not a chapter we need to add to our history. We believe this option of amending our Constitution would leave our Constitution open to be rewritten, and to take from the words of James Madison, a convention would be courted by the most violent partisans on both sides with insidious views, who under the mask of seeking alterations popular in some parts but inadmissible in other parts of the Union might have a dangerous opportunity of sapping the very foundation of the fabric. There have been over 400 applications made by states in our history asking Congress to call a convention. 3 times in the 20th century, attempts have been made to secure the number of applications necessary to convene an Article 5 convention. And we came dangerously close in the 1980s when we were just 2 states shy of having the 34 necessary. So this isn't a new idea. This is not a new idea. The idea that conservatives are offering this up as a solution is what's new. So now we have leaders in the conservative movement like radio talk show host Mark Levin and National Homeschool Legal Defense Chairman Michael Farris encouraging conservative activists and legislators to work toward what Texas Eagle Forum believes has the potential of being a disastrous convention meant to amend the U.S. Constitution. They believe all the problems of a runaway government can be solved by amending our Constitution, since Congress has been too slow in cutting government spending, i.e., balancing the budget. Mr. Farris and Mr. Levin are promising conservatives this convention, once convened, will be controlled in content, limiting amendments, and amended only by conservatives. In an article entitled, "Why Liberals Cannot Realistically Hijack the Convention of States," Mr. Farris answers the question, can the left hijack this process and obtain constitutional amendments that will grow the power of the federal government? His answer is absolutely not. Mr. Levin says there can be no runaway convention because 3/4 of the states still need to ratify the amendments the convention proposes. These men have no way to back up their guarantees. Article 5 leaves all authority to the Congress. It does not stipulate rules, delegates, or limitations on the number of amendments offered. Once it is convened, our Constitution is up for open heart surgery. In fact, precedent backs this up, with the first and only Constitutional Convention held in 1787 to ratify the Articles of Confederation. James Madison writes in Article 40 of the Federalist Papers that delegates to the 1787 convention were sent, and his quote is, for the sole purpose of revising the Articles of Confederation. However, once convened, rules and the document to be ratified were changed. The Articles of Confederation were replaced with the Constitution. It originally took 100% of states to amend the Articles of Confederation, but they had constant problems with absences, plus they did not have the votes to ratify the new Constitution. So the number was changed to 3/4 of the states. And I understand that, I believe it was Mr. Ferris was first. I came in late. He said that groups have said that our Constitution was illegally adopted. Well, nobody in our groups ever said that. We're simply trying to make the point that the rules and the scope of that convention changed at the convention. As I said,
it was initially called for articles of the convention to be, or for articles of states to be amended.
I'm sorry?
I'm sorry, you're saying it was initially called for
James
amending the...
Yeah, the James Madison in the Federalist Papers says it was called for the delegates were sent for the sole purpose of revising the Articles of Confederation.
And the Articles of Confederation they set that aside and went with
the U.S. Constitution. Yes.
Okay.
But nobody in my group has ever said that it was illegally done. As I said before, Mr. Levin claims that the convention gets out of hand with amendments. Ratification by state legislatures will keep things in check. But he is forgetting that Article 5 stipulates ratification can also be done through state conventions. So ratification would be done by the populace, not by elected officials. This was done in 1933 to bypass conservative legislative bodies when the 21st Amendment was ratified to repeal the 18th Prohibition Amendment. The fear that this can be a runaway convention has always been there. The late Justice Warren Burger wrote, Chief Justice Warren Burger wrote, there is no effective way to limit or to muzzle the actions of a constitutional convention. After a convention is convened, it will be too late to stop the convention if we don't like its agenda. In 1972, Robert J. Huber, a former congressman from Michigan, asked the Library of Congress and the U.S. Supreme Court if there was any precedent or provision that could restrict to one issue a convention called under Article 5 and petitioned by the states. The amendment being considered at the time would prohibit cross-district busing. The reply was, in 1796, Secretary of State Thomas Jefferson asked the Supreme Court the same question, but the issue was dealing with Indian treaties. The court refused to consider the issue until it became a contest of law. In other words, once a convention is convened and you don't like what's happening, file a lawsuit to limit it. Only then would the court consider the matter. Jefferson determined the risk was too great and did not proceed. Congress, over the past 40 years, has shown that it also has the fear that this could be a runaway convention and so must be controlled. According to a study done by the Congressional Research Service, and I know this was mentioned earlier, then this is I'm quoting from this study. Once valid applications have been received from 34 states, Congress has maintained the call for an Article 5 convention must come from Congress, and Congress has the authority to limit the subject of amendments to be considered. It is at this step that Congress has asserted in the past, but not provided in legislation, its power to set limits as to the convention's agenda. This suggests a delicate balance of authority. I'm still quoting from this paragraph out of here. This has a suggested delicate balance of authority. The states are authorized to apply for a limited convention, but only Congress can guarantee by law that a convention so summoned would confine its recommendations to the issues within its mandate. For instance, the Senate Judiciary Committee in 1984 claimed for Congress the power to both set and enforce limits on the subject or subjects considered by a convention, summoned in response to state petitions that specified the consideration of amendments in particular areas. Why does your mouth always go dry when you're trying to give a testimony, or at least mine does? This was stated in the committee's report on Senate Bill 119 in the 98th Congress. And the bill was called the Constitutional Convention Implementation Act of 1984. Thank you very much. I appreciate that.
You better smell it first, I know.
I'm a good
Be
Baptist. I
careful
wouldn't
there.
be.
So.
Chairman, we keep that one back here.
Again, this bill was called the Constitutional Convention Implementation Act of 1984. These folks that keep saying that if it's a convention called under Article 5, it's not a constitutional convention. Even the Congress thinks it's going to be a constitutional convention. The Constitutional Convention Implementation Act of 1984 did not become law, but between 1973 and 1922, 22 bills were introduced in the House and 19 in the Senate that sought to establish a procedural framework that would apply to an Article 5 convention. None have become law. And for Mr. Ferris to say a while ago that, to look at this and say, and again, this came from this report, that this was only 40 failed bills, and not to at least acknowledge that this would give you a glimpse into the mind of Congress. It's like President Obama saying after the 2014 elections, I heard the 2/3 that didn't vote. I mean, you have to at least acknowledge that this will show the mind of Congress. And the Congressional Research Service report looked at all these bills proposed to see some similarities. This gives an idea of Congress's thoughts of structure of an Article 5 convention. Similarities in the bills were: delegates would be based on apportionment among states based on the formula provided for the Electoral College, with each state assigned a number equal to its combined Senate and House delegations. Based on this, Texas would have 38 delegates. This is very different from one state, one vote. Most provided delegates and convention staff would be compensated from federal funds. The vice president was authorized in most versions to preside over the inaugural session and swear in the officers. So if this were to happen in the next 2 years, we would see Vice President Obama opening up this convention. Most bills required that amendments were to be approved by 2/3 of the whole number of delegates, and required to be consistent with the issue which the convention had been summoned. Excuse me. The convention was given a limited term, generally either 6 months or 1 year. Most bills authorized states to rescind ratification of proposed amendments at any time before the constitutional ratification threshold of 3/4 of the states was attained. This should make it clear to those who see Congress as having only an administrative and clerical role in calling an Article 5 convention, that Congress sees their role in a whole different light. Now, Phyllis Schlafly has written extensively on the dangers of calling a constitutional convention. It subsequently dubbed it the CONCON. Mr. Ferris and Mr. Levin, knowing that her position against a CONCON is widely held by most conservatives, decided to rename the convention. Mr. Ferris calls it the Convention of the States, and other groups are calling it an Article 5 convention. And now there's a group that is calling themselves Contract for America. And let me interject here real quick. After hearing Nick's testimony a while ago, I know that Nick, it's my understanding that compact is drawn up under the Compact Clause of the U.S. Constitution. But Nick said that this was only going to be a commission and it wouldn't need congressional approval. But he also said that it was going to be a binding, solemn agreement. Well, this report says the Interstate Compact for a balanced budget amendment would require congressional approval under the Compact Clause because it proposes actions that would redefine via a constitutional amendment Congress's taxing and spending authority, arguably shifting the balance of power within the federal system of government. So if it's going to be binding, it's got to have some kind of teeth to it. Somebody's got to approve it. So I just would interject that there.
I think generally the way compacts work is the states contract together, and then Congress has an up or down vote on it. They can't vote to amend it or not amend it.
Okay, but still, it has to have would have to have congressional approval, and it would also.
It is, as I understand it, an up or down vote. Yes.
Okay, and then it would also have to have president's signature, according to this report. I'm not an authority.
And I'm not either. But my understanding of compacts was that it did not take that they did not have to have presidential
I believe that this report says that it does, but again, that's, I'm
One of
going
us
by
is
what
wrong.
this report. This is a
Maybe.
very. If you haven't, if your committee and your staff, if they haven't looked at this, it's got some really good information in it. And to pick up where I was, I mentioned these three groups. All of these groups contend this convention is different from a constitutional convention. And again, I mentioned a while ago, even our Congress thinks it's going to be a constitutional convention. This has created such confusion within these groups that instead of trying to repeal a plank already in the Texas Republican platform opposing a constitutional convention, a group added a plank calling for the legislature to petition the Congress to convene an Article 5 convention. We've got two opposing planks in our Texas platform. Call it what you will. Article 5 is very specific about the process to convene a convention to amend the Constitution. If ever convened, it will, without a doubt, open the possibility of the most profound document ever written by man to be rewritten. And then I just want to close with a couple of other thoughts. We've all of us that have been in politics for a while, and I've been doing it for a good 20 years now. And I've been to 4 of the last 5 national Republican conventions. This is going to be a convention of not just Republicans, but Republicans and Democrats. And when I speak on this, I've got some 30-second clips on my PowerPoint that show 30 seconds of the 1968 Democrat convention, inside and out. And if you remember the chaos at the time, maybe there's people in the room that are not that old, but I was a teenager at the time. But I mean, the most pressing issue of the day was getting out of Vietnam. But I mean, it was chaos out and inside and outside. Then I show another 30-second clip of the 2012 Republican National Convention, where we had the 99% outside picketing. So to think that this convention, if ever convened, is going to be just a well-run, orchestrated convention and there won't be some problems, I think is not facing reality. And also, just to mention this, I came across something when working on this testimony. Have you ever heard of the Young Turks? They claim to be, it's a website, and they claim to be the largest online news network. And it's very, very liberal. And they've got a lobbying group called Wolfpack. And they're out there lobbying for an Article 5 convention, whatever they want to call it, but a convention convened under Article 5. And their big issue is campaign finance reform. There's another group, a website that's called movetoamend.org. And their big issue is capitalism. They want to amend our Constitution to deal with that. And they've got every liberal group you can imagine. There's 3 or 4 pages of Sierra Club, MoveOver.org, every liberal group you can imagine listed there. So this is not going to be a convention that's going to be attended by just conservatives. And we've had all these attorneys speak here today that are authorities. Well, I'm not. I'm just a business owner, mother, grandmother, wife. And political activists, unpaid political activists, by the way. But I think we could bring in just as many lawyers from the other side. And so we can all produce quotes from our founding fathers. But I do think that this would open up our Constitution to a very great danger. So thank you very much.
Members, any questions for Ms. Carlson? Representative Workman.
Thank you, Mr. Chairman. Ms. Carlson, thank you very much for being here. So I have a couple of questions for you. First is, given your perspective on a convention for proposing amendments, why do you think we put that the founders put that in the conventions, the Constitution to begin with, if it was such a dangerous thing?
I suspect that it was one of those compromises that when they were writing the Constitution, I don't know for sure, I'm not a historian, but I would think that it would have been a compromise. And I believe in something that I've read, it was a compromise.
There were 2, as you pointed out, there were some other times when a convention of the states has been proposed. The first one that got anywhere was when we got the 17th Amendment. Are you aware of that? You know, where the 17th Amendment was a direct election of senators.
Okay, well, I'm not.
Okay, well, there was a Convention of the States initiative and movement throughout the country to go to direct election of senators, which, by the way, I think was a mistake, but it was what happened. And we got very close to the 2/3 required, and we know that the Congress then proposed that amendment and sent it to the states, and it was ratified. And then you mentioned what happened in 1986, where we got very close to that. And are you aware of kind of what happened then when we got very close? The Congress acted, and we had the Gramm-Rudman Act that was there. So I guess my point is that Convention of the States helps move Congress. And so even if there's not an actually convention called, Congress does seem to act when the people began to rise up. And that's what one of the things that I think this is about. And I do believe that it's in our Constitution for a reason. And I don't believe we should be afraid of it. And I believe it's there so that the people can say to the U.S. Congress, you're misbehaving and we're going to fix it. And that's why I think we need to do this. But I appreciate your perspective on it. Thank you for being here.
Can I just comment real quick? First of all, I'm against I like electing our U.S. senators. I don't want the legislature to do that, so I would be in favor of that amendment that was passed. Secondly, if we nudge our Congress by these resolutions, that's great if it's used. But what if we actually get to the 34 and then they're compelled to convene a convention? So that's a risk that I think we shouldn't take. There must be other ways to nudge our Congress without taking that chance. And so I appreciate the opportunity to talk.
Members, any other questions? Pat, thank you very much. It's great to see you. Good job on testimony. Chair calls our last witness of the day, Roman Buehler from the Madison Coalition. Mr. Buehler is the National Director of the Madison Coalition, an organization dedicated to restoring balanced state and federal power and curbing the authority of overreaching federal regulators. He originally went to Washington in 1989 and served as committee counsel to then Representative Gingrich's committee, and also served as the election counsel to the United States Committee on House Administration. Roman, thanks for being here today, and if you would just, for the record, state your name and who you represent.
Yes, Mr. Chairman and members of the committee, my name is Roman Buehler. I represent the Madison Coalition and myself. And I want to thank the members of the committee, Mr. Chairman, and you for your extraordinary patience in listening to all of this testimony. I truly believe that there is no more important meeting of state legislators that's happening today than the meeting that you've convened, because the country is in a serious crisis, and the authors of the Constitution gave us Article 5, and they made you, state legislators, the guarantors of American liberty. Now, I was a committee counsel in Washington, D.C. for 14 years. I was Newt Gingrich's first committee counsel. And I came to Washington believing that Washington could fix itself. And my conclusion after 14 years is that people go to Washington to accumulate power. And they don't stop accumulating power when they get off the plane at Reagan Airport. They continue. And that if we are going to reverse the accumulation and abuse of power in Washington, D.C., if we're going to reduce the accumulation of debt, that discipline is going to come from you, state legislators. So I'm here to talk about the Regulation Freedom Amendment and the very specific problem that we have, that regulators are now able to dictate pretty much without accountability policy from Washington, D.C. And we fought a revolution to end taxation without representation. We now have regulation without representation. And it is extraordinarily dangerous to our liberty and probably the single greatest impediment to economic growth and the creation of new middle-class jobs that we have. So every voting Republican in the U.S. House of Representatives, along with a number of Democrats, voted for a bill called the REINS Act. And the REINS Act would solve the problem of regulatory abuse by requiring that Congress approve major new federal regulations so that regulations, like laws, would have the consent of the governed. Polls show that by 2 to 1, people favor that concept. But the problem is that Congress is too divided, and so it's very unlikely that such a bill is going to get 60 votes in the Senate, very unlikely that the President would sign it, and there are a number of people, including some folks at the Congressional Research Service, that believe that a law alone cannot give Congress a legislative veto over administrative branch regulations, that the Constitution does not allow that to be done by law. So there are now a group of people, including 400 state legislators, 2 governors, and 8 state legislative chambers, who support something called the Regulation Freedom Amendment. In the same way that states were able to force Congress to propose the Bill of Rights 225 years ago, in the same way, as you've heard, that states were able to force Congress to propose the 17th Amendment, and in the same way that states helped force Congress to propose presidential term limits 50 years ago, if 2/3 of the states could agree on a specific amendment, history demonstrates that those states could almost certainly force Congress to act. Why? Because Congress is terrified of a convention that would be more powerful than Congress. And so they will do almost anything to avoid the states calling and forcing them to call such a convention. And so if 2/3 of the states agree on an amendment, we think there's a very strong probability that Congress will propose the amendment. Now, what happens while that process is going on? 2 things happen, and we can absolutely guarantee that these things happen. First of all, as the group of states who want Congress to propose this amendment grows, the issue of should federal regulators keep their power to dictate from Washington, or should federal regulators be accountable to elected officials, is going to be a very prominent issue. Every state legislator in the country is going to have to answer that question. And I predict that most state legislators are not going to describe their governing strategy as, well, let's elect a chief executive and let that chief executive dictate for 4 years. That's not a popular position. And so as more and more legislators of both parties join the effort to restore accountability to regulators, regulators are going to begin to worry. They're going to begin to worry, as many don't now, that if they propose regulations that anger large constituencies, they may lose all of their power. And I've talked to dozens of groups who are who feel that federal regulators ignore their concerns. And I predict that as you, state legislators, create an environment in which legislators fear losing their power, federal regulators are likely to become a great deal more reasonable, a great deal more flexible, and most importantly, a great deal more respectful of the interests of states. And that happens before we get an amendment. That happens because you all, as state legislators, urge Congress to act. Now, you've probably seen the language of the regulation, but it's very, very simple. It says, whenever 1/4 of the members of the U.S. House or the U.S. Senate transmit to the President their written declaration of opposition to a proposed federal regulation, it shall require a majority vote of the House and Senate to adopt that regulation. So the goal here is to make sure that only regulations which 1/4 of the members of the House or the Senate believe deserve review, only those regulations are the ones that require congressional approval. The average regulation on the number of nails that need to be driven into a piece of wood, those regulations don't get reviewed. Now, some people say that, well, this would allow a small minority to basically freeze the operations of government, that no more regulations would ever be allowed, that this would cause gridlock in Washington. Well, the first thing I would suggest is that for 225 years, Congress, and it's always been a messy process, has always come to an agreement on an appropriation to fund the government. When compromise is required, Congress is quite capable of making sure that things continue to function. But the second question, as I would ask, is we have 90,000 regulations, and there are different ways to count. My question is, if there never were another federal regulation, would government grind to a halt? Can we manage with 90,000, or do we need 10,000 more? And so, given the risk of overregulation, which is very real and ongoing, versus the risk of underregulation, if you think that's a risk, our democracy is far safer if regulations like laws have to receive the consent of the governed. And I would also say, and I am old enough to remember President Nixon. And President Nixon did some wonderful things. But President Nixon also ordered his IRS to audit the tax returns of people who opposed him. And that was wrong. And we probably have not seen the last president who someday might choose to abuse their power. And I leave out, there's a debate about whether the power is being abused today, but that's a political debate. But I think all of us can appreciate that if a president, through his or her regulators, can regulate out of existence entire industries, entire sectors of our economy, that president has enormous power to intimidate their opponents. And that kind of power is not the power that the authors of the Constitution intended the president to have. And that our democracy is safer if regulations, the laws that can fine us, that can put us in jail, if those laws, those rules have to be approved by elected officials. So what are we asking the legislators to do? We believe that the best way to force Congress to act is to create a community of 4,000 legislators in 34 states who agree on a specific amendment. And we believe the best way to accomplish that is for states like Texas to pass a resolution that has already been passed, as I mentioned, in 8 state legislative chambers, urging that Congress propose the Regulation Freedom Amendment. And by passing that resolution, we create the community. We create this as a national issue. We send a message to regulators and to Congress that something has to be done. Now, what can states do to strengthen their bargaining power beyond passing a resolution? And here,
and that would be a resolution on any amendment that we propose, not just, I don't want us to do testimony on a single amendment today.
That's right. But what you can do, you have already discussed the faithful delegate law that you were planning to introduce. The passage of that law by the state of Texas and by other states, which already in effect has been mentioned in 6 states, the passage of that law sends a message to Congress that it's not inconceivable that at some point, if states become angry enough, they could force Congress to call a convention and limit that convention to an up or down vote on a specific amendment. Congress may or may not believe that states would ever call a convention broadly limited to one or more subjects. But I believe they would be absolutely terrified because they understand that states might well call a convention if they knew that it could be limited to just an up or down vote on an amendment. So I know I'm standing between you and lunch. I appreciate the opportunity to testify. I think you have an opportunity here to use Article 5 in the way that states have traditionally used Article 5 to rein in the growth of federal power and to do it in a way that perhaps unites both people who want a convention and people who are still unconvinced of the need. And if we are going to rein in federal power, we are going to need a united effort. We are going to need a very, very broad effort, and this effort for this specific purpose offers you a way to do that. Thank you so much for your letting me testify, and I'm happy to answer questions if there are any.
Members, any questions? Great. And just to summarize, make sure I understand what you're saying. Your position is that if 34 states will pass any of these amendments that have been discussed and are being discussed, that even if a convention is never called, just the mere fact that 34 states have taken that affirmative of action, that it will have a compelling effect on Congress to move in the direction of forms as proposed in those amendments.
Yes, I believe that the most powerful impact is when 34 states pass a resolution agreeing on the text of a specific amendment. Congress can always take an idea and distort it if it's, well, we want a balanced budget amendment. Well, what does that mean? What's the enforcement clause? So I think that the way we get reforms is when state legislators do what they're really good at, which is bring consensus out of concern. And if 34 states agree on a specific amendment once states have proved that they can force Congress to propose an amendment, the entire balance of federal and state power will be transformed, because members of Congress will understand they're no longer beyond accountability. That at any point, 4,000 legislators in 34 states could force them to propose reforms.
Good. Do you have something? Okay. Mr. Bueller, thank you very much for coming. Thanks for being willing to stay to the last.
Well, thank you for giving me the opportunity to be here.
Members, just kind of talking about next week, we're still and for the public, once bills are filed, then they have to be read in the House one time before and they're referred to a committee at that point. And we're still going through the referral process on a regular basis in the House. And some of the bills, or some of the issues that were discussed today, those bills have not yet been referred to this committee. We do have some others on other topics that have been referred. So, members, I'm not sure that we're going to convene a committee hearing for next week. We may wait until a few more bills come here, because I want to take the most advantage of your time and be as efficient as possible. So if you'll kind of tentatively keep next Thursday on your calendar, and we'll figure out very shortly if we'll need to meet by then. If not, I'm sure we will by the following Thursday. Is there any other business that the committee needs to discuss? Great. Well, if none, the chair hears none, and the House Select Committee on State and Federal Power and Responsibility is now adjourned. Thank you.
Thank you, Mr. Chairman.
Yep. Appreciate it.
Particularly interested in talking to you because you were the member of course. Thank you for sticking it out.
Oh, come on, man. Come on. Hey, man, they're starting. Good. Thank you. Appreciate it.